ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? We will give all the adjournments when the matters are called, not at the time of mentioning, because everybody, the entire list is they're making mentions repeatedly. So we will grant, we will consider, provided there is a reasonable cause, when the matter is called, not at this time. Any memos, give it to the court officer. No, take that. The memo is fine, seeking to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes.
For the respondent in this case, my lords.
Which one?
Serial number 1, my lord.
Huh.
Respondent, my lords. In this case, my lords, your lordship has passed the order in the month of September 25th, my lords, regarding direction has been issued to the trial court to dispose of for the matrimonial dispute of the year 2015, my lords, within 2 months. In that, my lords, your lordship may kindly come to the operative portion of the order, my lords. Prayer that order number 3, my lords. If the arrears are not paid, the matter shall not be taken up by the trial court for final adjudication. If all the arrears are paid by the husband within a period of 2 months, the main MC, it shall be disposed of from the date of clearing the arrears, my lords. That is, my lords, 2 months from the date of the arrears, that is not mentioned here in my lords. For that reason, my lords.
What is that?
My lords, the 2 months after the clearance of the arrears, within 2 months, this honorable court has given direction to dispose of the matter.
The date of clearing of the arrears.
Please, my lords,
What is not mentioned?
No, my lords, this is confusion by the trial court, my lords.
If it is confusing for the trial court or for anybody, court can't help it. It isn't.
My lords, what happened, my lords, already, now it is 4th month, my lords, after the order passed by this honorable court, after me clear the arrears of maintenance, my lords, now 4th month is running, my lords. The petition.
Please understand, Mr. Counsel, what is there to be clarified in this?
My lords, here.
How can it be a for being spoken to?
My lords, here, if all the arrears are paid by the husband within a period of 2 months, the main MC itself shall be disposed of from the date of clearing the arrears. Here, as per the trial court judge, my lords, it is she is stating that there is a direction to clear the arrears, sir, but there is no direction to dispose of the matter. That is what that is what understood by the trial court, my lord. That is my difficulty, my lord, sir.
No, where did the court say that the matter has to be disposed of within 2 months?
My lord.
Where did the court say that? Where did the court fix the time frame?
My lord, your lordship, on that day, my lord, sir, that maintenance amount has been answered from 10,000 to 20,000.
Yes.
And that 20,000 has to be paid for that 2 months, my lord. Your lordship has given direction on that day, my lords, to dispose of the matter within 2 months, my lords. Because of that direction only, my lords.
I think in the open court, this is how it is dictated. It is in the open court. I said the maintenance is enhanced from so and so, so and so. The husband shall pay the arrears of maintenance. For paying of the arrears, I fixed 2 months. Then I said, if the arrears are paid within 2 months, expeditiously dispose of.
No, my lord. 2 months, your lordship has the time, my lords. 2 months, the time has been fixed, my lords. Because matter of the year 2015, this is went up to Supreme Court, my lords. This is transferred from the Mumbai Bandra court to Bangalore court, my lords. Even there is the order from the Supreme Court.
Where is the counsel for the petitioner?
Not present, my lords. Even he is dragging the matter before the trial court, my lords. Intentionally, he is paying one or the other applications, my lords. Even one day I have finished my cross-examination of the petitioner, my lords, after the disposal of this writ petition, my lords.
No, it is virtually reviewing the order for being spoken to. Where is the for being? What is the any typography?
My lords, at least my respectful submission to your lordship is that, my lords, at least already, my lords.
Can that be done in a for being spoken to? That I want to know.
Year, that is 2 months has been mentioned, no, my lords, here.
2 months for the arrears.
No, my
because you wanted the time. So 2 months arrears for paying the arrears, 2 months time is fixed. If you pay the arrears, then the court shall proceed with the matter and expeditiously. What is happening is when the court is consciously not fixing the time in some of the matters, court is only saying conscious the expeditiously.
No, on that day, my lords, your lordship directed to dispose of the matter within 2 months from the clearance of the arrears of maintenance, my lords.
I think that 2 months you have understood this 2 months. When the court fixed time for 2 months for paying the arrears, you understood the other. Let the other side be there. Because this type of cases, if the court starts entertaining, then there is no end to it. Let him come, pass over. Yes, next. Hmm? Hmm. Please, is the mic on or not?
I've challenged the order passed in the miscellaneous number 2 of 2016 in dated 15/12/2017, my lord. It's an ex parte order. Ex parte order, I was challenged in miscellaneous. That the miscellaneous is also dismissed for default, my lord. The main suit is, my lord, suit for recovery of money of rupees 8,20,000.
When you suit is of which year?
Suit is
Of which year?
2011, my lord.
2011 suit. When were you set ex parte?
In 2013, my lord. The order is
2013. When
13.
did you file the IA to set aside that order?
In 2015,
2015. When was it dismissed for default?
2016, my lord.
And you come before this court in the year 2018.
Yes, my lord. My lord, this is the case, my lord. The basically it's a check bounce case, my lord. Check bounce.
We are not on the merits of the matter. We are on the point. Suit of 11, this ex parte order 13. What did you do till 2015? Then that is dismissed in 2016. You come up before this court filing a writ petition in 2018.
My lord, I was not aware of any of the proceedings until ex parte order passed and
The miscellaneous is filed.
Yes, miscellaneous
in the year
is filed.
2014.
Yes,
Then
my
from
lord.
2016, from the date of order till 2008 to 18, what were you doing?
My lord, because of first
No.
of all, my lord, I'm a widow
Court
because a
cannot-
deceased person
Doesn't
is
matter. Doesn't matter.
expired and my husband is expired and I don't know any knowledge about the legal and I'm a widow, my lord. I'm not having any source of income. So on other grounds, I have not approached the. Yes.
I am for respondent, my lordship.
Yes. Where is the order impugned? Order impugned.
Order impugned, my lord. Page number 16, my lord. The petitioner are hereby directed to deposit the decretal amount as per the direction on OS 3/2011 with the interest on before 12/1/2018, my lord. Yes, my lord.
I think that's how it is adjourned. The matter is adjourned. You
Yes,
said
my
you
lord.
get instruction.
Yes, my lord. I'm not one citation. I'm relying on the ex parte order can be allowed with the judgment, my lord, without the condition, my lord, because no, I'm relying upon.
Not a precedent.
No, it's not a precedent, my lord. I'm relying upon judge because of so many reasons, my lord. I'm not aware. I'm an uneducated.
No,
I'm
I'm
a
not aware.
widow. I'm no source of income. Only the 15,000, whatever the.
You have filed the suit. How can you say you're not aware?
No, I have not filed, my lord. I have not filed. First, it is a check bounce case.
No.
After deceased of the person, they filed recovery of suit with the liberty, my
Yes,
lord.
Mr. Counsel.
I am for respondent number 1, my lordship. Actually, the case has been dismissed for non-prosecution. I handed over the entire file to respondent number 1. 1 week time may be granted to contact the counsel parties.
You have given a
Last year, the case was dismissed for non-prosecution.
Even before this court also.
Yes, sir.
Please come.
Then they are thereafter filed the recall application. The application has been allowed, madam. 1 week time.
Agreed with orders passed in. Miscellaneous number 02 of 2016, dated 15th of
My lord,
December.
the operate portion of 16, my lord, page number 16, my lord.
Yes.
The petition filed under order 9 of Rule 9 Code of CPC is hereby allowed. Petitioners are hereby directed to deposit the decretal amount as per the direction on OS number 3 of 2011 with the interest, my lord. My petition is allowed and I'm relying upon only on the decretal amount, my lord. The decretal amount is an ex parte order which is passed in OS, my lord. That amount can be stayed, my lord, because as per the Supreme Court citation, my lord, ex parte order can be set aside without the condition, my lord.
Notice has been
For
served to the
court
respondent.
either to-
Notice has been taken,
The-
in spite of they have failed to appear before the trial court, my lordship.
The present petition, the agreed with orders passed in miscellaneous number 02 of 2016 dated 15 December 2017. The plaintiff is before this court. The plaintiff had filed a suit for recovery of money. In the said suit, the petitioner, the said the respondent herein has filed a suit for recovery of money. And the petitioner herein is a defendant in the suit. In the said suit, the petitioner is an ex parte order is passed on that ex parte, and the suit was decreed on 31st of July 2014. Thereafter, miscellaneous number 2 of 2016 is filed before the first edition senior civil judge at CJM, Mandya. The court, by order impugned, had allowed the application the court had allowed the application and directed to deposit the decretal amount as per the directions in OS number 3 of 2011 with interest on or before 12/1/2018. Then the office is directed to place the records before the court. While passing such an order, the court has observed that it is not a case where the petitioners are rustic villagers. The petitioners are educated and employed as well. It is clear from the cross-examination of PW1 that she is disinterested in gathering information regarding the status of the case. Now, nothing much has been and appears to have been elicited to the witness PW1. The court has observed that, however, an opportunity could be given at the same time. The interest of the respondent number 1 could as well be safeguarded. And the petition could be allowed on terms as the petitioners themselves have sought for, and accordingly pass the order. Agreed with the said order. The present writ petition is filed. Then counsel appearing for the petitioner submits that the petitioner is a widow and she is not aware of the pending proceedings. As such, she could not represent before the court. She further relies on, there is a judgment. He relies on the judgment of the apex court in Ms. Troy's Corporation Limited versus National Ventures Limited,
In point number 20, my lord. May I permit it to read, my lord?
wherein the apex court observed that the order of the High Court directing deposit of 75% of the suit claim as a condition precedent for condoning the delay and for setting aside the ex parte decree was unwarranted. The ends of justice would have been met if an order of cost was imposed on the appellant as a condition precedent for condoning the delay and for setting aside the ex parte decree. Imposing a requirement of a deposit of 75% of the suit claim is disproportionate and would have to be set aside. Relying on this judgment, land counsel for the petitioner submits that the condition imposed by the court in directing the petitioner to deposit the decretal amount is a onerous condition and the court ought to have allowed the same on some cause. Then counsel appearing with respondent submits that earlier the suit was dismissed for non-prosec, the present writ petition is dismissed for non-prosecution, and he has given up, you have given up wakalat. Yes,
Previous already filed. Thereafter, they have taken. Previous already filed wakalat, my lords.
you are submitting that, you have given up wakalat.
No, entire file has given to the respondent, my lords. After dismiss for non-prosecution.
When the matter was dismissed for default before this court, he has given up the entire file to the respondent. Thereafter, the
Number
present
one. Respondent number one.
respondent number one. Thereafter, the restoration petition is filed. On 14/2/2024. So this court, next paragraph, on 14/2/2022. This court has dismissed the petition non-prosecution. Then IA number 1 of 2024 is filed to recall the said order, that was recalled by order dated 14/10/2024. The suit is filed in the year 2011. The ex parte order is passed. The defendant was set ex parte in the year 2013. IA is filed in the year 2014. And looking at the facts and circumstances of the case and exercising the discretion, the court had imposed a condition that the decretal amount has to be deposited. Thereafter, the present writ petition is filed. Even the writ petition is also dismissed for non-prosecution. The plaintiff who had filed the suit in the year 2011, even till now, the proceedings could not be concluded, and he could not enjoy he's not in a position to enjoy the fruits of the decree. The consistent conduct of the plaintiff, the defendant, the consistent conduct of the defendant petitioner shows that she has no intention, and there are no bona fides on the part of the defendant in pursuing the litigation at every step, before the trial court, before the appellate court, and before the trial court, as well as before this court. The judgment that is relied on by the counsel, referred to supra, is in the facts and circumstances of the particular case. In this case, this court is of the view that the order that is passed by the court is a reasoned order, considering the facts of the case, and further looking at the manner in which the matter is pursued by the petitioner. This court is not inclined to interfere with the order passed accordingly. Dismissed.
For the respondent.
My lord, the
Argument was completed, my lord, by the counsel for the petition and aforesaid. Matter is set on for the dictation of the.
Oh, this is the case where.
Regarding a dispute regarding drawing of the.
Correct. No, a form is required.
No, order 34/7, it won't speak. In what matter decree is drawn? Either in 7A, B, C, or it is silent.
No, let's see. CPC.
Madam.
CPC.
There is no law. Form is there, but there is no law.
Order,
34, Rule 7. In a suit for
preliminary decree in redemption suit.
only preliminary decree is to be drawn. In which form it is not stated. In a suit for redemption, if plaintiff to succeed, the court shall pass a preliminary decree. That's all. In which form it is not stated.
So what it should contain, further it is there. What it should contain, the preliminary decree, look at it, read A.
Ordering that an account to be taken of what was due to the defendant at the date of such a decree for principal and interest on the mortgage, the cost of the suit, if any, awarded to him. And third one, other costs, charges, and expenses properly incurred by him up to date in respect of the mortgage security. Together with
Because
there are,
it should contain all these particulars. Otherwise, how can it be executed?
my lord, the judgment and decree is confirmed in RA. And RSC also it is confirmed. Now how they can dispute
No,
it?
it has to be modified. It has not modified, it has to be in consonance with that. Otherwise, how now, for example, how the executing court will do it, if there are any amounts that has to be paid or that
It is
has
paid
to be
already.
recovered.
It is paid already.
Huh?
It is paid. 1,000 rupees was the due. It is paid.
Let us see.
Redemption of mortgage.
Let us see give the file. Which page? Page, the decree.
FDP, my lord. Decree is at page number 34. The suit filed by
34.
34. By the plaintiff in OSM 294.99 is decreed to the cost. It is ordered that the plaintiff is entitled to redeem the mortgage. The suit plaintiff shall deposit the mortgage amount of ₹1,000 in the court within 3 months from the date of the judgment with the notice to the defendant. Thereafter, the defendant mortgagee shall execute the redemption deed within 1 month and get it registered at the cost of the plaintiff and deliver the possession of the mortgage property to the plaintiff. If the defendant mortgagee fails to execute the mortgage deed and redeliver the possession of the property, the plaintiff is at liberty to get the same through the process of the court. The plaintiff at liberty to institute the proceedings under order 20 rule.
Where is that impure note?
At a page number 133.
133.
Undisputedly, the suit filed by
The respondent herein has filed the suit for redemption of the mortgage dated 5/6/1978
yes,
and filed OS number 294 of 1999. That came to be decreed by judgment and decree dated
decree dated 8 March 2010.
8th March 2010. Aggrieved thereby, the defendant had preferred RA number 19 of 10, which came to be dismissed by judgment and decree dated 2010.
It has been confirmed. Judgment is confirmed.
Who filed the appeal?
They are filed. Other side, they are filed.
And that's what the appeal is dismissed by judgment and decree dated. I can see 2010. I have written which year is that?
8th October 2015.
It is
8/10/2015.
8/10. 8/10/2015.
Yes.
RA came to be dismissed by judgment and decree dated 8/10/2015. The same is carried in appeal, that is in RSA number 291 of 2016.
Yes, ma'am. RSA 29/16.
RSA 29/16,
It was dismissed on 4/9/2017.
49,
2017.
2017 was also dismissed, confirming the judgment and decree passed by the trial court. Thereafter, the decree holder has filed the EP. In that, the IA is filed questioning the maintainability of the execution proceedings. It is a case of the judgment debtor that the decree is not drawn as per what is it, Appendix C,
Appendix Form 7ABC.
Appendix Form 7ABC of Order 38, Rule 8.
Yeah, Rule 7.
Order 38, Rule 7. It is, and that application came to be dismissed by the executing court. The executing court, while dismissing the said application on the maintainability, had observed that
(133).
page number
133.
the court has observed that undisputedly, the suit filed by the petitioners invoice number 294 of 1999 for redemption of mortgage deed is decreed as per judgment and decree dated 8/2/2010. Against that, an appeal, a regular appeal and a further regular second appeal were filed. Finally came to be dismissed by judgment and decree dated 4/9/2017. The court observed that there is no document to show that the respondent has challenged the order of the High Court. Therefore, the judgment and decree passed by the court invoice number 294 of 1999 dated 8/3/2010 has become final. As per Rule 7, Order 34 of CPC, the final decree has to be drawn on the preliminary decree for redemption of mortgage deed. The contention of the respondent that there is defect in preliminary decree cannot be considered as preliminary, The preliminary decree passed by the court is confirmed by the appellate court and also further the High Court. And the court has come to the conclusion that as per Rule 7 and 8 of Order 34 CPC, the present proceeding seeking drawal of final decree is maintainable, and accordingly directed the matter to be listed by 22/8/2019. Land counsel appearing for the petitioner judgment debtor submits that what is executable is a decree, and the decree that is the preliminary decree that is drawn is a defective decree, and it is not in consonance with Order 38 Rule 7 and the
34 Rule 7.
or 34 Rule 7 and the Appendix A to C.
Appendix 7A.
7A to C. Appendix 7A to C. When the preliminary decree is not drawn as per the provision, the decree is a defective decree, which is not executable. He relied on some judgment. It is there in the file.
1998 Supreme Court. Case
Please
number
pass on
590.
that. He had relied on the judgment of the Apex Court in Bar Council of India versus Om Prakash, Faizi and others. No, it is Sudesh, not the judgment. Sudesh Vittal, Hanam Sheikh and others versus Sadanand Shivrao, Koppal and others, reported in 1998. 8 SCC 591, wherein the apex court observed that it's being an obligation of the court to prepare the preliminary decree in accordance with Rule 7 for the lapse of the court. Appellant cannot be penalized on the ground that the application for the final decree was barred by limitation. Relying on this judgment, land council submits that the Anita, yes, the earlier matter is posted. The judgment is in the earlier matter, give it to her. It is submitted that as the decree, the preliminary decree was not drawn as per the procedure contemplated. The same is not executable. It is submitted that the court ought to have considered the objections that are raised by the judgment debtor, and without considering any of the facts as well as law, the court had dismissed the application. Then counsel appearing for the respondent decree holder submits that Order 34 Rule 7 do not contemplate drawing of a decree in a particular manner. He submits that Order 38 Rule 5 only stipulates what should a decree contain. He has drawn the attention of the court to the judgment and decree, submits that the judgment, the decree contains all the ingredients what are necessary to be there in a decree. He submits that a suit that is filed in the year 1999 and the RSA dismissed on
4/9/2017.
4/9/2017. 4/9/2017. Even from there on, even after lapse of 8 years, still the judgment debtor is the decree holder is not able to enjoy the fruits of the decree. It is submitted that the decree holder, only with an intention to protract the proceedings and to see that the petitioner do not the proceedings is coming up with one application or the other. He submits that the application needs to, the writ petition needs to be dismissed with cause. Next part. Having heard the counsels on either side, there is the material on record. The petitioner herein is the defendant decree holder or a judgment debtor. There are two suits filed. One is for redemption of the mortgage by the respondent herein, and a suit for specific performance by the petitioner herein. Correct?
Yes.
The suit filed by the petitioner herein seeking specific performance is dismissed, and the suit filed by the respondent herein seeking redemption of the mortgage was allowed. Thereafter, against the two judgments and decree that is passed in the two suits, two appeals were filed. Regular appeals were filed. Two appeals came to be dismissed. Then again, only one RSA is filed.
Yes.
One RSA is filed arising out of a suit for the redemption of mortgage. As far as a specific performance suit is concerned, no second appeal is filed. When the appeal that is filed is dismissed, the petitioner has kept quiet and he has not carried the matter further. Before any of the courts, it is never the case of the judgment debtor that the decree is defective. He himself has filed the appeals against a defective decree. If looking at the case of the petitioner herein, it is stated before this court that there was no occasion for him to say that the preliminary decree is defective, as that occasion has come during the final decree proceedings, but not before. This case is a classic case, how the litigant is abusing the process and the procedure and the remedies that are available to the litigant. The mortgage deed is of the year 1978. And the suit was decreed on 8/3/2010. Even till 2025 also, the suit, the proceedings are not concluded. And proceedings are not concluded. This court has perused Order 34, Rule 7. What all Order 34, Rule 7 contains and what has to be specified, a perusal of the decree shows that court has drawn the decree in accordance with the same. Where is the, I've seen the order, where is the decree? Come to the decree.
On page number 41. Page number 38, typed copy at page number 44.
The court has drawn the decree in consonance with Order 38, Order 34, Rule
Rule
7.
7.
Rule 7. A person who has questioned the preliminary decree in by way of a regular appeal and a regular second appeal. Now, in execution proceedings, cannot turn around and say,
In the final decree proceedings.
in the final decree proceedings, cannot turn around and say that the decree that is drawn, which is questioned by him, is not in consonance with the provision. It is nothing but the delaying tactics of the judgment debtor, and these kind of technicalities cannot come in the way of the court in executing the decree, where the preliminary decree has become final. Final when the RSA filed by the plaintiff, the RSA filed by the defendant petitioner has attained finality, considering the manner in which the proceedings are dragged on by the petitioner decree holder. This is a fit case to impose exemplary costs. Accordingly, the writ petition is dismissed with costs of ₹25.
Okay.
Yes, sir.
Ask maybe. Ask me, asked maybe.
Why 2010 decree even till now, and what are those kinds of applications?
At least 5,000
10,000.
grateful.
For the petition in this case.
Yes.
I'll do it in the course of the day.
Needful is done.
No, in the course of the day, I will do it.
And then council submits that the needful will be done in the course of the day. List this matter on Monday, on Tuesday. Yes, next. 5
1 week time may be given, my lord.
weeks time, default order.
But sure.
Next.
6 minutes, I pray for 2 weeks time that to trace out the correct address, take steps in both the matters.
WP of 2017.
Yes,
Uh,
I'll take final limit.
No, 2 weeks, take 1 week. 1 week default order.
Then second matter, interim order may kindly be extended.
6.1.
Yeah, yes, madam.
Even for the first time also, 2017, you take an interim order. You
Yes.
will not take steps.
No, regularly I'm taking steps. Even the month of September, I took some of the respondents served. Now the LRs of the D1 served. Now the rest of the some unserved case.
Come up with an application for
No,
substitute.
I'll file necessary application.
6.1, then council shall come up with an application for substituted.
In both the cases, I'll
In both
file.
the cases, we shall come up with an application for substituted service. This is not, you shall file an application within 10 days, your date after 10 days. If the application is not filed by then, both the writ petition shall stand dismissed without further reference to the court. Interim order, just look at it. If it is extended on the last
Yes.
occasion, extend.
It is
Yes,
extended.
next.
For the petitioner. Petition minutes was dismissed for default.
Rectification of office objections raised on 1/24.
Yes, my lords. The date mentioned is my lords.
Do it,
Yes,
do it tomorrow.
please, my
This
lords.
is smarter tomorrow if the office objections are complied with,
Please, my lords.
or else the petition shall stand dismissed.
Please.
Okay, for the petitioner, in the last occasion, my lord, I have taken the undertaking that I will file an wakalat, NOC wakalat. My lord, after verification, my lord, in the amended cost list which is they have filed, they have left out the 2D, my lord. I may permitted to file a fresh amended cost title. 2D, and they had inserted R6 as a,
Whatever the objections shall be complied with by,
2 days accommodation.
yes, within 2 days,
Much of.
same default order.
Hearing for petitioner, my lord. Grant 1 week time to bring a loss of respondent.
A week's time for bringing the alerts on record, give a date, I mean, not date necessary, default order, yes. Yes, next. Password. Same. 12.
My lords, I appear for the, my lords, in this case, I appear for the petitioner, my lords. My lords, what has happened is, after filing of NOC, we try to trace the power of attorney holder. That person's address is also not being traced. And this matter is, my lords, the petitioners had preferred IA number 20 and 21, wherein to recall the order of the
No,
civil
no,
court
no.
where they had closed the
If you-
evidence.
If you look at the cost title.
My lords.
But non-filing of amended cost title by the order dated 4/1/2020.
I will do the necessary, my lords. I will do the necessary, my lords.
Please do it.
3 weeks time may be given, my lords, because I am not getting the proper address of the power of attorney holder also. I'm finding that particular address.
2009 interim order.
Yes, my lords. I do agree, my lords. I will do that, my lords.
Not 3 weeks.
2 weeks may be given, my lords.
List is matter after 10 days. By the time all the office objections shall be complied with and the process shall be paid. Order
Much obliged.
shall stand dismissed without further reference to the court. Look at the interim order. If it is extended on the last occasion, then in all the cases, if it is extended, then you extend. Yes.
I prayed 2 days. I will fix the documents.
Finally, 2 weeks time, no further time.
Yes.
Are not taken, the petition shall stand same default order. Yes, next.
My lord, I'm filed a recalling application, my lord, which is served to the WhatsApp, my lord. To the other side council, my lord, served to the WhatsApp, my lord. That's a recalling application, my lord. Earlier, my lord, 1 week's time,
Rectification of office objections raised on IE.
that is the office objection.
What is that? Look at it. What are the objections?
Served to the what? I have served to the WhatsApp, my lord. Not served. I have served to the WhatsApp to his, that is served to the WhatsApp, my lord, to his mobile number, my for council.
Fine.
I
The
will
section has to know
take a print and
Yes.
file it, my lord.
the office objection shall be complied with by tomorrow.
Yes, ma'am, tomorrow, maybe.
By tomorrow,
Posted.
if then list this matter on Tuesday.
Please.
A week's time or else the petition shall stand dismissed.
Hearing for respondent number 15, my lord.
Same, a week's time for default order, next 17.
My lords, for the petitioners.
Where is that letter? The court had disposed of the petition by order dated 6/6/2023 and directed the executing court to conclude the final decree proceedings on or before 21/12/2023. Now requisition is sent by the judge seeking extension of time. Stating that the respondent number 12 compromised item number 7 of the properties with the petitioners. And both the petitioner and the respondent jointly paid time to compromise the petition with remaining items. Hence, the court has granted time. And finally, the matter is posted before the Lok Adalat. Hence, sought for another 6 months' time to dispose of the entire petition for remaining respondents. Considering the same, finally, another 6 months' time is granted to conclude the final decree proceeding. Yes.
My lord, in 18, my lord, the same advocate is representing for respondent 1, 2, 3, my lord. Respondent number 2 served, my lord.
Lord,
Who appears for
IA, Mr. SV Bhatt.
Lord, I am on line, my lord. I am for the respondents 1 and 3. An application has been served on me, and my lord, the application again says that, my lord, they are supposed to substitute the name. Instead of that, they want to amend the name. They are supposed to substitute the name in terms of the court order also, because, my lord, earlier.
What is this amending and substituting?
My lord, now, my lord, the Manipal Hospital, my lord, has acquired 100% of the share of the respondent number 1, Columbia Hospital, my lord. It is merged with the Manipal Hospital. That is the reason, my lord, name of the respondent number 1 has to be changed as Manipal Hospital, my lord. For that, my lord, the IA has been filed for amendment of name of the respondent number 1, my lord. My lord, in this case, my lord, if Manipal Hospital, my lord, undertakes, my lord, that they'll contest the suit and comply the decree in the place of Columbia Asia Hospital, my lord, this case can be disposed of, my lord.
So now third respondent is General Manager, Columbia Asia Hospital.
That has to be changed.
Mr. Counsel.
Yes, my lord.
If you look at the IA,
yes.
First respondent is Manipal Hospitals.
Yes, my lord.
And the third respondent still remains to be Columbia Hospitals.
Yes, my lord, but in this case, my lord, they purchased 100% of the share, my lord. It can be concluded today itself, my lord. That
no, that's what I'm saying.
Amendment is not necessary at all.
If you're saying,
yes, my lord.
In the place of Columbia Hospitals, no, it has to be Manipal Hospital. Then where is this? Where then?
The respondent number 1 is the main party, my lord. Respondent number 1 is 3 is also not a necessary party, my lord. All are the same, my lord. Same organization, my lord.
Yes.
Same institution, my lord.
Yes.
My lord, yes, no need to drag the case, my lord. It can be concluded today itself, my lord.
If you permit the court, it will be concluded. Let me ask him. Yes.
But insofar as first respondent is concerned, my lord, name has been changed. I have already said that I only filed the memo along with the incorporation certificate of the new name of the Manipal Hospital also in the place of Columbia Asia. I have no objection for substitution of the name from that of
then what about notice to third respondent?
Insofar as notice to third respondent is concerned, the description continues to be managing director of
Manipal,
That's
Columbia
why-
issue. It can't be. No,
He cannot
because
represent, he
no,
cannot
he-
represent him.
well, I was representing then the managing director who was the Columbia Asia Hospital managing director. Columbia Asia Hospital managing director did not doesn't continue to be the managing director as of now. Manipal Hospital has a different managing director altogether. He has not been made as parties. Third respondent continues to be the managing director Columbia Asia only.
No, company is a party represented by whom?
Company is a party. Let them delete both the other two persons. Again, the first
Yes, madam.
respondent, if they want to continue, let them
Being
continue.
represented by Mr. Tufan Ghosh and Dr. Viju Rajan. According to them, he is not represented by, company is not represented by Viju Rajan.
They are not the necessary
First of all,
parties, my lord. As of now.
you say that a particular company is represented by a particular person. According to
Yes.
them, he is not.
Yes,
Along with the memo, I have filed the wakalat also. In the wakalat, I have produced the power of attorney copy also to the effect that who is going to represent
So
Manipal
Viju,
Hospital.
Viju Rajan has nothing to do with this Manipal hospitals.
Yes, my lord.
Then how can he represent?
Yes, my lord, I'll file necessary IA for that.
The
From 2022, I have been representing this, my lord. This is now the petitioner.
He'll carry out the necessary corrections and file a fresh, the copy of the cost title, amended
Right.
copy of the cost title. Yes,
Previous application, they had
When-
filed previously
when can you file?
application that has been dismissed. 3,000
When can you
rupees.
file?
cost.
My lord,
Because,
both application not present.
Huh? When can you
So-
find that amended cost title?
Within 2 weeks, my lord.
This is matter after 2 weeks. By the time the needful shall be done, or else the petition shall stand dismissed without further reference to the court. Yes, 19.
Notice in this matter, I appear for the petitioner. What are the
There is a respondent.
what
Was it heard before?
are-
Was it heard before?
No, my lords.
Password?
Yes.
Yes, next.
Petitioner, my lords. Was the petition was this. Now we have filed an application seeking for recalling of the order of dismissal of non-prosecution, my lords. It was dismissed on 19/11.
Was it dismissed?
Lords, it was dismissed on 19/11/2019, my lords.
When is the IA filed?
My lords, IA was filed on 23/10/2020, ma'am.
23,
10/2020.
2020.
Yes, my lords.
What was the reason for the delay of these
My
3
lords,
months?
My lords, the delay, my lords, is that, my lords, 19/11, my lords, there were some typographic, some annexes which need to be typed. My lords, we were getting it typed, my lords. By then, the courts were closed due to the onset of COVID. My lords, after immediately, whenever the court opened, my lords, we have immediately filed the application, my lords, in the year 2020 itself.
Yes.
2018 appeal, mein, after 7 years, suit could have been disposed. Mein.
Illa,
So injunction
I
is
verified, my
granted,
lords, it is posted for
maintaining the
hearing.
status quo. Suit should have been directed to disposal. 7 years he did not prosecute the matter in the writ petition itself.
That is the unfortunate fate of all these matters.
7 years, my lord.
Ending
7
from
years,
19 to
2000.
25, we don't know.
MA is of the year 2018. Suit is of the year 2018.
Against interim injunction.
Pardon, my lord?
It is
In-
against.
Yes, ML, trial court rejected my relief regarding injunction. MA, it was confirmed in my name, reversing the,
Court has granted injunction or status quo?
well, it's an injunction of obstructing my possession,
Injunction-
obstructing possession.
Injunction. in the
Let
year
it continue and suit be disposed of.
15. So now we are in 2025, let that injunction will make it absolute. Let the suit itself be disposed of within 6 months.
Please.
Be taken up tomorrow, my lords, I shall seek
That is, that's the
instructions.
same order will be passed. Tell your
Yes.
client.
Grateful.
Petition. I filed an application to bringing the LRs. This is respond number 1, my lord.
Proposed response.
You appear for the proposed response.
Yes, please.
So now the IA, that IA for implead can be ordered.
Please, my lord. My lord. They have also filed an application. I have also filed an application. Both are same.
So how many IAs are there?
Totally,
IA
my
1
lord,
of
there are
23, 3 of 24. IA 1 of 23 is filed by whom?
1 of 20 filed by the petitioner, my lord.
3 of 24?
That is also filed by me.
You say I have filed, he has filed, something you are saying. Both are filed by you.
My lord, 1,
The 1
2,
of 23 and 3 of 24.
3 of 24, my lord, is filed by him.
That's what I'm
Please,
asking.
please, I'm sorry. I mistaken the year.
1 of 23. And mhm.
IA 1 to 3 are filed by the
Hmm.
petitioner. And IA 4 of 23 is filed by the impleading applicant.
IA number. Where is LR application by him? 1 of 23 is Karno delay. 2 is setting aside the abatement. IA number 3 is filed by the petitioner to bring the LRs of R1 on record, deceased R1 on record, and the deceased LRs, LRs of the deceased R1 themselves have filed an IA number 4 of 2023 to implead them as the LRs of the deceased, considering the application that is filed. IA number 1 of 23 is allowed by condoning the delay of 172 days. Consequently, IA number 2 of 23 is also allowed by setting aside the abatement. And both IA number 3 and 4 are allowed, declaring, bringing to bring the LRs on record. This LRs of deceased are on record. Next, the petitioner shall file the amended cause title. Next, what are the other IAs?
May I make one submission?
1 minute.
Already.
1 bar 24 may be, my lord.
1 minute, 1 minute. IA number?
1 of 24 is filed for substituted service in respect of R2.
That may.
You are
I'm for
referring. No. The IA number 1 of 22 is filed for substituted service of notice on R2. Already Mr. So-and-so has already filed wakalat in respect of R2. As such, no further orders needs to be passed in IA number 1 of 24. Next.
One submission. Yeah.
Mm.
That is name has to be rectified by respondent number 1A and B and C. So
I may be permitted to rectify it as per the memo. my-
Next memo is filed by the advocate for the proposed R1A to RD.
and
That it should be as R1B and it is stated that the names of R1B and R1C names are wrongly mentioned in the LR application.
I may
The
permit.
petitioner shall carry out the necessary amendments as per the memo filed by the council for the proposed, the council for the impleted, the council for the LRs of the deceased R1. Yes.
Interim order may kindly be extended.
The order is extended, list is filed on Thursday.
Please,
By the time you do it, we'll hear it and
Please,
dispose it off.
please.
Yes.
I appear for the respondent.
Hmm.
Your Lordship, I filed an IA for recalling the order dated 9/9/24.
When R2 died,
R2 died on 6/12/2014, Your Lordship.
and then why should we?
Your Lordship, I apologize, Your Lordship. It was an
It's
honest.
not about apologizing.
Please, Your Lordship.
2014, it is a writ petition of 2019.
19, Your Lordship.
By the
I-
time you file the writ petition itself, is no more.
Please.
Where is the question of now passing any recalling that order?
The
Whatever you want to do, go do before the lower court. As far as this is concerned, we will not review it. 14, filing the writ petition in 19 without even bringing them, and LR petition in the year 2025.
Your Lordship, it was an honest miscommunication, Your Lordship. Our party also was not aware that respondent number 2 is has died, your lordship, and because of that we've continued, and only in the year 2000.
Let them suffer for not,
No, your lordship.
yes, we'll hear this, application itself, writ
Please.
petition, will not recall that order and pass orders. This matter also, list on Thursday. Yes,
Please.
next,
Your lordship, there's an interim order, may kindly.
If
Yes.
interim order is there,
My
extend.
lords, one submission. My lords, kindly 1 week time may be granted, my lord. My senior is not very.
This is matter on January 28th.
Much obliged.
Yes. No representation for dismissal tomorrow. Yes.
That's for the petitioner, my lords. We're seeking a week's time, my lords.
Bye.
That's some inconvenience, my lords. May be taken up on next week, any date, my lords.
Wednesday, no further time. No further time will be granted. This is matter on Wednesday.
Great.
No representation for the petitioner. List this matter for dismissal tomorrow. Counsel for the respondent is present.
And for the petition, your lordship, on the last occasion, the
Also, they
respondent,
were not present.
they are sought for time, your lordship.
No representation for the respondent. The land counsel, the petitioner is present. This is matter as parte tomorrow.
Your lordship, if I may request for Monday, your lordship, some inconvenience.
Tuesday, parte as on Tuesday. Not tomorrow,
Monday.
not Monday.
There's an interim order, your lordship.
We'll see. If it is extended on the last occasion, it will be done.
Obliged.
Lords, for the petitioners in this matter, my lords.
Respond.
I've instructed my clients, my lord, with respect to the nature of the petition and the consequences with this petition, my lords. If my lords could have this on Monday or Tuesday, my lords, I'll submit my arguments. If otherwise, they do not compromise before the executing court, my lords.
My lord, my anxious submission is this. An award by the labor court was put in for execution before the competent civil court. Then, my lord, the attachment warrant was issued and sale notice was issued. That was stayed on the ground that, my lord, the present applicant is an agreement holder, but she is the daughter of the original JDR number 2, under whom my client's father worked, my lord, earlier as an electrician. Award has been passed. Evidence is recorded. If my friend makes some payment, my lord, it serves the purpose.
No, we'll have it on Wednesday. If you feel that.
Yes.
With a frivolous one, we will dismiss with cause.
Please, my lord. My lord, may I request for Thursday, my lord?
This is matter on Thursday at the request of land counsel for the petition.
Please.
Great.
Yes. No representation for dismissal on Tuesday. Same order.
Serial number 29.
Serial number?
29, madam. I request for a pass over, madam.
Pass over.
Yes, ma'am.
Same order for dismissal on Tuesday. Yes.
Please. My lord, I appear for the JDR, my lord. My lord, the anxious submission is this, my lord. A decree for declaration and permanent injunction was put in for execution. And ex parte order of granting police protection is ordered, my lord, without hearing me. Notice was dispensed. Therefore, my lord, the matter was, my lord, the stay was granted earlier.
Heard and counsel petition in part, no representation for the respondent. This is matter on, when is the other matter of your?
23rd.
23rd.
Please. Much.
Yes.
Yes, I am appearing for petitioners, your lordship.
Hmm.
In lower court, some 33.
In lower court, some negotiations are going on, your lordship. Kindly accommodate some time.
Interim order is there.
Interim order is.
That's a problem. Without interim order, you can negotiate, not with
No, your
interim
lordship,
order.
already filed
Let
application.
whatever happen, we'll have it on 29th January. This is not on 29th January. No further time will be granted.
Much
Yes.
obliged, your lordship.
For dismissal tomorrow.
Why not serial number 26, please?
Yes, next matter. Same order.
My lord, 26, I appear for the petitioner.
So
My,
long back. Now it is 36 is going on.
I apologize, my lord.
Yes.
Is it passed over, my lord? I apologize, my lord. I'll follow up with the bench at 1:30.
Yes.
Lord, I am for the defendant in the trial court.
Hmm.
The respondent filed the suit for bare injunction, wherein, my lord, they filed the application for restraining the defendant.
There is no representation on behalf of the respondent. For the counsel for the petitioner in part. List this matter as part heard on 29 January. Yes,
And date, my lord.
29.
Yes.
30. No representation for dismissal tomorrow. No representation for dismissal on 21st.
Your lordship, it may kindly not be dismissal, your lordship.
Huh?
But the thing is, both of us, the respondent and the petitioner, are challenging the same order, your lordship. We want the same thing. We challenge the order passed by the trial court in accepting the commissioner's report, your lordship. The petitioner and the respondent challenges that the same order. It may be kindly taken under preliminary hearing, your lordship.
Why?
I have no problem with
Let
it.
it come. Which is your matter?
I'm the petitioner in the connected matter.
38.1.
38.1.
Learned counsel appearing for the petition in 38.1 is present. No representation for the petitioner in 38. List 38 for dismissal along with 38.1. Same order on Tuesday dismissal.
Lords, appearing on behalf of petitioners, my lords. My lords, senior counsel appears in this matter, my lords. It may be taken up on 4th of February, my lords. Some inconvenience. Government appears, my lord, for respondents.
Is it okay with you? 4th of February.
Please, ma'am.
Yes, Mrs. Matter on 4th of February.
My lords, interim order may kindly be.
Please, the
extended.
short point is involved in this case. The matter is reported to that land grabbing protest.
Please,
At the
email
request-
address.
At the request of learned counsel for the petitioner. Yes,
Lords, interim order may kindly be extended.
look at,
Please.
yes, sir.
Oblige.
Same dismissal on Wednesday. No representation on behalf of both the parties.
Appearing for respondent number 3.
41 or 42? Yes.
Yes, ma'am.
Ready?
Yes.
Yes. What is the improved order?
The suit order, your lordship, what happened? In a suit for partition, excluding me, who I am the purchaser of property, I am defendant number 7. Plaintiff and the defendant entered into a compromise. In that compromise itself is unfair because the property which is sold to me has been divided between the plaintiff and the defendant because they are the family members.
You were a party.
I am not a party to the compromise. To suit, I am a party. I am the 7th defendant, your lordship. And that apart, your lord, again, they compromise, file another compromise petition, amending the earlier compromise petition, your lord.
There again, properties which have been allotted to the first defendant who has sold the property, for her share was again reduced, Your Lordship. And another is, again, amendment is made to that compromise, another amendment is made for to the compromise. My submission to Your Lordship, the first compromise, once it is ended in a decree, it cannot be compromised, again amended, Your Lordship. If they want to amend it, they have to withdraw that compromise, file a fresh compromise. Because once a compromise is accepted by the court, decree will be drawn, Your
By
Lordship.
virtue of the first compromise, what about your rights?
My rights, I have challenged that in a RFA is pending, Your Lordship.
Pending RFA, no, that decree itself is amended.
Yes, Your Lordship. When the RFA have challenged it, they amend the compromise petition, which was challenged in the RFA and entered.
There was no notice to you.
I was a notice means I am a party. Your Lordship will kindly say, the basic principle is, if a compromise is entered between plaintiff and some of the defendant, other defendants are not party to the compromise, the list goes on between that plaintiff and the defendant, Your Lordship. That has not been taken into consideration by the learned judge, Your Lordship. Yes, Your
The
Lordship.
first compromise,
Yes.
you are a party.
Yes, no, for compromise, I am not a party. That is my grievance. I have filed objection. There cannot be a
What did you got any interim orders on that?
No, I am RFA is pending, Your Lordship. No interim order. Yeah. Again, they amend the compromise petition. That cannot be done. Go on amending the compromise petition.
Your Lordship, the amendment that was sought was only adding the boundaries, because when the compromise petition was filed, the boundaries were not given and the name of the party was not given. The amendment is only to that effect. Annexure J may kindly be seen. The boundaries, that is the reason why the amendment was allowed. Without the boundaries, it cannot be executed. That is why the boundaries were sought to be added. Other than that, there was no other change made to the compromise.
What will happen to his fate?
Your Lordship, it's in the compromise petition, they have already challenged it in the RFA. How can they be aggrieved by this amendment? The boundaries are only inserted, no other change is made. No material change is made. Amendment may, the application may kindly be seen.
Where is that amendment
79.
sought? Where is the main one? The compromise petition is at page 91.
Annexure G,
Page 79.
74, Your Lordship.
Page 91, what is it?
Your Lordship, 79 is the amendment application.
Not amended. Original one is at page 91.
Or is it 64, Your Lordship? Compromise petition is at page 64, annexure G.
21 is second compromise.
Hmm?
That is the second compromise.
That is after the
Original one is at 50?
64, page 64. Annexure G. They are the purchasers of item number 6. In this petition, Your Lordship, if Your Lordship would see, they have only stated that so many acres would fall to that particular party in every item. Whereas the amendment which is sought is annexure J. I is at in page 79. 79. What they seek is in para 3 of the compromise petition after line 4, the boundaries, the schedule is sought to be added to the compromise petition. That is what is sought after every paragraph. With the details of the property and the boundaries.
So what is the prejudice cost to you now?
No,
As far as in the compromise, Your Lordship, as far as my vendor is concerned, first she is out. I have purchased item number 6. It measures 9 acres, Your Lordship. In the first compromise, she is allotted 4.5. In that 4.5, again, they divide between the other defendants, children of the first defendant. As a result, she will be left with only 1 acre. And that apart, Your Lordship, and the suit has to go on.
No.
Yes, Your
You
Lordship.
have questioned it in a RA.
Yes,
Your rights, if at all that compromise decree is not binding or your
Yes.
rights are affected, it will be decided in the RA.
yes, yes.
How are you agreed with this?
I agree with your
You are not a
lordship.
party to the compromise. That is your grievance. For
Yes,
that, you have already questioned it.
Yes, your lordship.
Whatever that happens between them now, how are you concerned?
The question is, your lordship, they go and file a final decree proceedings. Then the final
It
decree,
has to be stayed in your RA. They will go and file because there is a preliminary decree in their favor.
Yes, sir.
Unless or until that is stayed in the RA,
yes, your lordship.
they will go and file. What is wrong in it?
Your lordship will kindly say, under order 23, if the compromise is not fair, it is entered into to defraud one of the party to the suit, your lordship. That cannot be entered in.
That will be decided in the RA.
Yes, your lordship.
That will be decided in the RA. As far as this is concerned,
Yes,
this
Your Lordship.
amendment, you cannot be agreed again by this. That's for them. Now you will, once this is ordered, this will also be part of your RA. You will question it there. This amended decree, you will
My-
question it there.
My question is, your lordship, the compromise withdrawn is challenged in the RFA pending before us. Subsequent to that, your lordship, they cannot amend it by filing a order 6/17 application. That cannot be done. That the order passed by the court allowing that application, I am before your lordship. Therefore, that has
I'll
to,
record that it is open to you to question it before the appeal that's pending. It is open for you to question it before the appellate court, where your appeal is pending.
your lordship, may I place a decision of the Supreme Court which says,
Please pass.
how do we call it? 2022-5 Supreme Court cases. 2022-5 Supreme Court cases, page 449. Where I have the 449. Vote. In. I may read para 21, your lordship.
Yes.
A judgment by consent is intended to stop a litigation between the parties. Just as much as judgment resulting from a decision of the court at the end of a long drawn out fight. A compromise decree creates an estoppel by judgment. It is relevant to note that in Bairam Prasadi Gadiwala, this court held that the appellant therein did not raise any doubt as to the validity or the genuineness of the compromise, nor was a case made out by him to show that the decree was vitiated by fraud or misrule. While stating so, this court dismissed the appeal. A consent decree would not serve as an estoppel. Where the compromise was vitiated by fraud or misrepresentation or mistake, the court in excess of its inherent power may rectify the consent decree to ensure that it is free from clerical or arithmetical errors so as to bring it in conformity with the terms of the complaint. Undoubtedly, the court can entertain an application under section 151 of CPC for alteration or modification of the consent decree if the same is vitiated by fraud, misrepresentation, or misunderstanding. They should show this. Unless they can show it is vitiated by fraud or misrepresentation or misunderstanding, there cannot be amendment to the compromise petition. Amendment only boundaries.
Yes. Please come. Where is the impugned order?
In page 181. The
Agreed
reason
with the
of the is also
orders passed.
My lord, let them give and they will not change the share. Allotted Shardama 4 acres first. Until
Yes,
it is,
It is not changed.
until it is decided by the in RFA.
Agreed with the orders passed. You should have asked all this before the appellate court. The agreed with the orders passed in IA under section 151 CPC. by the legal heirs of deceased seventh defendant not to draw the final decree till the disposal of RFA number 694 of 2017. What did you write? Or of 2017 pending before this court. The respondent plaintiff had filed a suit for partition, which came to be dismissed by order dated 11/3. What is the date?
Compromise in that.
It came
This
to
order,
court
impugned order.
Impugned order is 26/4/19,
Page number?
ink page 181.
Three orders are there.
There are three orders, Your Lordship.
That is
That is the order sheet.
Subsequent to the amendment.
Subsequent to the amendment, three orders are there permitting subsequent.
Which you have questioned.
That annexure N minutes, all three orders.
All the three orders I have challenged.
181, page number 181.
That's what I'm, 179, you're not questioning.
No, not either. Page 179, no. In fact, they had made a submission before the trial court that the proceedings we state pending.
That is only
pendency
for
of
drawing up a
RFA.
final decree.
That was
179
dismissed.
is.
That order is not
Where
challenged
is the
here.
order?
Kindly see 181 minutes.
26/4/19, allowing the amendment.
Allowing the amendment and for changing the subsequent amendments for the.
First of all, where have you questioned it? Where have you questioned before the court?
They are not questioned because we objected for that. Our objections were not considered. Therefore,
Where is that objection filed, in which form?
this without notice, man. These three orders, the drawing up a final decree, we filed objection. That was not considered and proceeded to draw final decree. Thereafterwards, on 26/4/2019, as well as on 6/6/2019 and 25/6/2019, without notice to us, the court permitted amendments of the original compromise decree. Agreed by that, we are challenged saying that the court cannot.
One is dated 25/4/2019, where order 6/17 is allowed.
Next.
Other is?
Next page, my lord, 183, 6/6/2019. And 25/6/2019, the very next date. They try to withdraw the compromise again, the subsequent amendment and file a fresh one.
It was drafted wrongly, it was withdrawn and another amendment was filed, but the main order is 20, they are agreed by
Totally
that amendment.
three applications, my lords.
My lord, when the 6/6/19 and 25/6/19 court before passing anything, they should have heard me, that is the things. I am not there.
No notice is issued.
No notice. I am not
Only seven
heard,
defendants.
not heard on the matter.
The strike of all that, agreed with the order dated 25/4, all in
3
one
days.
writ petition.
Please.
Agreed with the orders dated, docket order dated 25/4,
Such
2019.
25/4/19 is not challenged. 26/4/19 is challenged.
Where is 26/4?
Only 81, your lordship did.
In the order sheet itself,
181.
page 181, the second date,
That is 26/4.
yes.
Ouch.
That's where it records, without boundaries, the FTP cannot be executed, hence IA is allowed.
You see the order, my lords, perused, none of them have filed objection to the IA. Without bona fide, FTP cannot be executed, hence IA is allowed. No notice to the seventh defendant.
Your
The
Lordship,
court finds that there are no objections to the amendment application, therefore it is allowed. And again, on the next date, amendment client carried out, amendment compromise petition filed. And 25.
Where is your prayer? I think that's the only way I can understand.
the
Prayer,
writ
Petition,
petition,
where is the prayer?
prayer is at 23.
page 23.
The present petition is filed, questioning the orders dated 26/4 to a relief like that is maintainable.
It is maintained because.
How can it be?
My lord, if I am challenging the 3 orders, the office may raise an objection as per the payment of a court fee, that's all. I can challenge it one day petition. Only question of paying another 200 rupees. The office has not raised even that, your lords.
Questioning the order dated 26/4/2019, 6/6/2019, and 25/6/2019, passed in voice number 146 of 2005. The defendant number, the at-large of the defendant number 6 or before the court. The respondents herein has filed a suit for partition. The defendant number 7 states to be the person who has purchased the property from defendant number 4.
Yes, your lord.
One, defendant number 1.
Defendant number 1.
Purchased the property from defendant number 1. When the suit was compromised between the plaintiffs and the other defendants, and when without considering the rights of the defendant number 7, an appeal was preferred against such judgment, the preliminary decree. While said preliminary, the regular appeal is pending before the appellate court, the decree holders have filed a petition seeking amendment wherein it is stated that in the compromise petition, the boundaries are not mentioned. Initially, the petition herein has filed a petition to stay the final decree proceedings, and that IA came to be dismissed. Thereafter, the court had allowed under application under Order 6 Rule 17. The court has observed that perused by order dated 26/4/2019, it is observed that perused and none of them have filed objections to the IA. Without bona fide, the FTP cannot be executed. Hence, IA. Without bona fide, the FTP cannot be executed. Hence, the IA is allowed, permitted to carry out the amendment to the compromise petition. Thereafter, on 25/6/2019, the amendment made is carried out, amended compromise petition filed. On 6, that is on 6/6/2019. Then on 25/6/2019, they,
Amended petition is withdrawn.
I'm not able to understand anything from this.
What
is this 25/6/2019 order?
This case is taken on board. Memo is filed. Here the memo, amendment petition dated 6/6/2019 is withdrawn.
Fresh amendment petition filed.
Case is taken on record, memo filed. In view of memos, amended petition filed on 6/6/2019 is withdrawn. Fresh amendment petition filed.
That's still we challenge.
Then fresh amendment petition, where are your objections?
I am not even noticed it.
There is
No notice. That is why I made a submission. It is against principle of natural stay. I was there, respondent am there. I am not been even in notice is issued to me.
No.
Yes, your lordship.
Instead of coming to this court,
Yes.
if you have noticed this, you should have gone to the very same court.
To the main amendment.
To filing a review, my lord.
Objections.
Objections, sir. Your lordship will kindly say, if I had the notice of these applications, when the applicants are filed, a requirement is that copies should be served on us. It is not done here. Had the copies have been served on us, we would have known that it is going to move before the court. We would have filed our objections.
This may be served on us, we will file objection.
6/6/19 is withdrawn on 25/6/19. Fresh amendment.
Stage of the survey, what is the stage now?
It sought stay of the proceedings in pursuant to these orders.
Now fresh amendment
Interim
petition
order
is.
granted in this. writ
Interim order is granted in this.
that
Yes,
is
ma'am.
the
For the
problem.
last 5 years,
Yes,
nothing is
that,
proceeding.
They have not prosecuted the appeal, they have been enjoying the stay in this writ petition.
In that
My
case, my lord,
may I make one submission, my lord?
fresh
It is
amendment.
not without bona fides, it is without boundaries. That is what is mentioned.
Yes.
They have typed it as bona fide.
Understand what is that?
No, it was stated as without boundaries.
In the earlier order, one order is said without bona fides, that is boundaries.
Boundaries.
The Lordship may see 25/6/2019.
Let us see by what is the reasons given for the granting of interim order?
No.
Where is the interim order?
That was granted on 14th August 2019.
And notice was ordered to us.
Issue emergent notice, stay as sought for till next date of hearing.
Office objections is kept open to your say other side.
You know? Stamp.
Substitution.
No, no.
Necessary application to be filed to bring the LRs and parte.
D5. What is it? D5.
The facts of the case are, the defendant number 7, already have written order. Defendant, the respondent heir has filed a suit for partition, and in that, the 7th defendant is the one who has purchased the property from the defendant number 4. In that, a compromise. Defendant number 1. In that, a compromise decree was passed by judgment and decree dated.
Twenty-five 6/2019, the court itself records, case is taken on board. When
I
it
want the date.
19/10/2016.
19/10/2016. As the rights of the 7 defendant are affected, he has filed a regular appeal. Pending regular appeal, the plaintiff and the other family members have filed an application seeking amendment that in the compromise petition, the boundaries were not mentioned. Initially, that amendment was allowed. Then thereafter, they filed another petition to withdraw the compromise petition, withdraw the amended petition, and file another petition.
No, another amended, the amendment was not carried out properly. That is why that was withdrawn and the correct
As,
amended petition was.
An amendment petition was allowed. And thereafter, when the amendment petition was withdrawn and another petition was filed.
Amended petition.
That's what. Thereafter, another amended petition was filed and the court by order dated 25/6/2019 had permitted the petitioners, had permitted the decree holders, permitted the parties to withdraw the petition filed on 6/6/19 and fresh 6/6/19. Questioning those orders, the 7th defendant is before this court. Learned counsel appearing for the petitioner submits that the court, without even looking at the fact that the interest of the 7th defendant is affected by virtue of a compromise which is entered into between the parties, had allowed the compromise, and allowing such a compromise petition is bad in law. Further, when once a compromise petition is, a compromise decree is passed and that is questioned in the appeal without any notice to him, filing a petition seeking amendment of the said judgment and decree, and further, again withdrawing the amended petition, filing another petition are not permitted, and the court ought not to have entertained the same. Learned counsel had relied on the judgment of the apex court in case of Ajanta LLP versus Casio Kasansik, something, take this, so and so, reported in 2022, 5 SCC, 449. He has relied on paragraph number 21, 22, 23, and 24. Relying on this, then counsel submits that the court has committed an error in allowing the amended petition and allowing, permitting the decree holders to amend the boundaries,
Add the boundaries.
to add the boundaries by way of an amendment without notice to the defendant number 7, who will be affected by such an order. It is submitted that the order passed by the court is contrary to law and also against principles of natural justice. Next part. Then counsel appearing for the respondent
Number 3, Your Lordship.
submits that.
If I may be permitted, the copy is served on them, Your Lordship. The application seeking amendment is served on them. It
Then
is
counsel
taken.
submits that. They have in fact served the copy seeking amendment on the petitioner's hearing. And they have not filed their objections. And without filing any objection, as if they are not aware of such an order passed, they have come before this court without even exhausting the remedies available to them before the court, before the executing court, before the trial court. It is submitted that when he has already filed an appeal and pending the same, if they want to stay if the final decree proceedings have to be stayed, they have to obtain the necessary orders in the said regular appeal, which the petitioners before this court have failed to, or a petition before this court have failed to obtain any orders, as they could not obtain the orders before the appellate court. They have come up with one application before the court to stay the final decree proceedings, and as well, now they have come up before this court questioning the amendment that is made to the amendment that is allowed by the court by inserting the boundaries. It is submitted that without the showing the boundaries, the compromise decree cannot be executed, and the court had rightly allowed the application. It is submitted that only to stall the proceedings and only to it is submitted that this is the writ petition of the year 2019, and the petitioner had by way of the interim order, the entire final decree proceedings, the state, though he was not successful in obtaining the interim orders before the appellate court, but in this writ petition, he could successfully stall, by obtaining the orders, could stall the proceedings. It is submitted that there is no illegality with the order that are impugned before this court, and the writ petition is liable to be dismissed. Next paragraph. Having heard the counsels on either side, there is the material on record. Whether the trial court was right in permitting the parties to compromise the matter, and in passing a compromise decree where the 7th defendant's rights are involved, is a matter of adjudication before the appellate court. If the 7th defendant's rights will be affected, if the final decree proceedings are concluded, then it is for the petitioner to persuade the court, the first appellate court, where the regular appeal is pending. Then coming to the amendment and the notice and other things that are mentioned, that are urged before this court, by way of this amendment, in the according to the parties, the boundaries are not mentioned in the compromise memo. And they want to, by way of an amendment, they want to show those boundaries. Otherwise, the final decree proceedings cannot be the executing court cannot execute the decree. As far as the decree, the preliminary decree is concerned, it is not stayed by the court. Now, even if this amendment is allowed by the court, and the petitioner is not remediless, this amended decree can always be questioned by him, but before the appellate court, where the appeal is pending. And on that ground, he cannot seek the stay of final decree proceedings in a writ petition or before the executing court when his remedy lies elsewhere. In the considered opinion of this court, the amendment the amendment that is allowed, no prejudice is caused to the petitioner, and it is always open to him to question the same before the appellate court where his appeal is pending. Accordingly, the writ petition is dismissed.
Great. Kindly press for 2 days accommodation, my lord. File
What
has,
has happened on the last occasion?
it has not been listed, my lord.
It's coming up for the first time.
Please.
I'll list it on Tuesday
Please,
at the request of land counsel for the petitioner.
please.
Yes.
I prefer the state in this case.
Land counsel for the petitioner. There is no representation on behalf of the petitioner. The AGA for R1 is present. List this matter on Wednesday for dismissal.
For the first respondent.
No representation for the petitioner. Counsel for the respondent is present. List this matter for dismissal on Wednesday.
Sorry, number 1.
Counsel for the respondent is present. No representation for the petitioner. List this matter for dismissal on Wednesday. Yes, for dismissal on 29th, no representation on behalf of both the parties. On 29th, same order. Yes,
I prefer the state in this case.
Place for adjournment, my lord.
right.
Senior is not in station.
Intermodal is there.
Preliminary.
At request of counsel, the petitioner release this matter. Interim order extended. Finally, at the request of counsel, the petitioner, this matter on 30th. No further adjournment shall be granted.
Obligement.
Yes.
Lord, may I have it up to 2 weeks, madam.
Why?
Need collect some papers.
I'm appearing for the respondent, my lord.
Only the matter coming up on the allowing the
At
application and
the
order.
request of counsel, the petitioner, it came up before me. Poses matter
I only
15.
requested for an adjournment.
Interim
So
order
I could
will
not
be-
secure the record.
No, what is not relevant on that day when you got interim order? How is it relevant today? Document which
Please.
was not relevant when you file this petition How is it relevant today?
I don't want to put the matter insufficient, this thing. Only matter is that applications which has been filed before the trial court, my lord, that the original I had
What is the interim order?
interim order.
Impugned order.
So
Interim
all the
order,
proceedings are stayed, my lord.
impugned order or
No, all the proceedings are
the
stayed.
It's a suit of 2006.
suit of 2006
Hmm.
on the document which alleged to have been executed in the year 1991 for a suit is for a specific performance.
I can accommodate this matter on Tuesday, no further time.
30th, my lord.
Why 30th?
Little
can't
inconvenient.
have
Next
interim
week
order.
I am little inconvenient.
Suit also.
Tuesday is on 22nd, my
We'll
lord.
have it on 24th.
24th, my lord, please.
Yes.
Interim
yes.
order may be extended.
This is matter on 24th. Interim order earlier granted is extended till then. The no adjournment will be
Mature.
granted.
Please.
If the adjournment is sought, stay will be vacated and adjourned. Yes, next.
In so many occasions, they took a time, my lord, and several
It will not
occasions.
happen. It will not happen.
No,
this
we
time.
will be, in fact, but for the papers, I am ready for an argument today.
Yes, 51.
Obliged, my lord.
Application with a list of witness was filed at the time of before tendering the evidence. But annexure B, page 11, straight away,
What is the suit for?
suit for injunction. The list of witnesses were filed,
You are the plaintiff.
a plaintiff. Now annexure B, this writ petition can be disposed of. So for B, page 11.
Yes.
This first witness sought to be examined is a power of attorney holder of the plaintiff. By mistake, is cited as a witness because he is the one who has signed the witness as a salary, under which the plaintiff claiming title and also possession. Second witness, he died in August 23. Therefore, now clearly record that witness one is holding a power of attorney on behalf of plaintiff. Second witness died, there
Is no more.
no more. Therefore, question of considering all on merits writ petition would not survive. So
Why it was rejected was not because the GPA holder, he was examining himself as PW1.
That's what
He also
I'm
sought to examine himself as a witness as well.
that
So
was a
the observation.
mistake since copy.
No, even on that count.
Please, if that's the case, Manoj, if he's coming and stepping into the shoes as far as the witness is, as far as the plaintiff is concerned, it's fine. He cannot come as a witness.
I will
separately
just
again.
give a date of death. It is in the mobile.
As long as it's clarified that he does not come in as a witness again.
No, definitely not
That
a
will not,
witness. Once he tendered.
Itself is making.
If
a
that's,
submission.
Manoj, as long as that is recorded, that's more than enough.
That's what will
Please.
be recorded. Yes. Where is the impugned order? Page number.
Lord,
Page number,
the lords will kindly.
I mean, no, you
Eight-
can look at that date,
Lord,
Mr.
eight-
Counsel.
19, page number 90.
It starts, Manoj, it starts at 16 minutes.
No, you please give the for the date.
My lords
the
will
death.
kindly see, page 16, it starts impugned order.
18, para 12 is the impugned order reference.
So when is
Sir,
the
ಹೇಳ್ತೀನಿ
date
sir.
of death?
ಅದನ್ನ ನೀವು date ನೋಡಿ sir.
What
Date
your
of death.
date of death? I will
Sir,
just.
ನೀವು ನೋಡಿ, ನಾನು ಹೇಳ್ತೀನಿ.
ಅದು ಏನಾಗಿದೆ?
In the meantime, I'll record the
Okay.
reasons.
Hmm.
Agreed with the order. Dated
10/10/2019.
10/10/2019. Invoice number 580020, in IA number 6 and 7.
My lord, it's only IA number 7. 6 was allowed, they have not challenged that.
I number 7, invoice number 58002013. The plaintiff is before this court. The plaintiff has filed the suit for permanent injunction. The power of attorney holder of the plaintiff has filed I number 6 under order 11. You said I number
7, my lord.
Seven.
7.
Had filed I number 7. For what?
For production of list of witness.
7 under order 6 rule 1.
16 rule.
Read with section 151 CPC, seeking permission to produce list of witnesses. That is one Sri Vittal Murthy, son of late P. Rangaswamy, and Sri V. Panduranga, son of late V. Rangaswamy, stating that during the course of the trial, the plaintiff could not produce the list on the earlier date of hearing. The same was opposed by the defendants. According to them, only to delay the proceedings, the present application is filed. And also for the purpose for which they want to examine them is also not stated. The court had dismissed the application, observing that the name of the witness number 1 shown in the list annexed with IA is none other than the husband and GPA holder of the plaintiff. As such, he cannot be permitted to prosecute the case on behalf of the plaintiff as GPA, as well as a witness at the same time. And when it comes to the other witness, witness number 2, who is none other than the brother of the GPO holder, has been stated in the affidavit. As such, he can also be, even on that count also, the application cannot be allowed. Accordingly, IA number 7 is dismissed. When the matter came up for hearing, the counsel submits that as the first witness, as stated in the IA number 7, is the GPA holder and also a witness to the sale deed. And he is pursuing the suit as a GPA holder on behalf of the plaintiff. He cannot be a witness. And when it comes to the second witness, he died on
29/8/2023.
He died on 29/8/2023. 2023. Land Council submits that on these both the counts, the nothing survives for consider. The application need not be considered. There are no orders required to be passed on the merits of it.
That observation that Vittalmurthy shall be represented as a GPA holder, and shall not come in the way technical. There should not be any problem tomorrow.
No, I said that is the case of the respondent, the observation of the court.
Yes, but he shall be represented as a GPA holder of the plaintiff.
That he can do, not as a
That
witness.
observation may be. That observation may be required because.
Also have no problem.
No, my lord, insofar as, because now the law is very clear, my lord, and so far as 3 Rule 2 is concerned, a husband can always represent the wife. You don't even require an application to that effect. So I don't see an issue here.
But tomorrow, since application is rejected, is a witness and GPA, the technical aspect shall not come in the way of the power of attorney tender evidence on behalf of plaintiff. That's only a request.
You were not cited as a witness being a power of attorney holder. You were cited as an independent witness.
Yes.
Then instead of saying all that, just as the land council submits that so and so. After that, the first witness who is a GPA holder, he can represent as a GPA holder on behalf of the plaintiff, but he cannot be. He cannot give advice. Cannot be cited as a independent witness. And as far as the second witness is concerned, that he is no more. In view of the same, this court finds no reasons to interfere with the order passed.
Yes.
Much obliged.
My wakalat, senior counsel, Mr. K. Suman, after his wakalat, I filed my wakalat today.
Your name is there?
Siddharth Suman, Siddharth Suman.
Yes.
Please. Obliged.
Yes.
Appearing for the
What
petitioner.
happened to this screen? Anita, what happened to this screen? Yep.
I'm appearing for the petitioner, my lord. I pray for 2 weeks' time since my senior is not keeping well. He's unable to appear today, my lord.
Let's look at give me the docket. We'll see, docket. You have an interim order,
Yes, my lord.
2019.
Yes, ma'am.
When do you want? Finally, no further time. If you want, we will vacate the stay and grant interim order.
My lord, 28th is possible, ma'am.
Let's just mark on 28th. No further adjournment will be granted. If any adjournment is sought, the stay granted by this court stands vacated.
No, the interim order may be extended.
Yes, extended till that day. Yes.
Here for the respondent number 1 to 3, my lord, praise for short accommodation.
Why?
Matter is likely to be settled.
Huh?
Yes, matter is likely to be settled before trial court, my lord. I request for 2 weeks, my lord.
This matter, the request of counsel respondent. That a compromise talks are going on. Let's this matter on 10th of February.
Much up.
Grateful to my lord.
Yes, my lord. My lord, I appear for petitioner, my lord. My application for impleading in FDP proceedings dismissed, my lord, against which the present writ petition is filed. That final decree is for partition.
Nobody is appearing for this one.
My lord, served unrepresented.
Unrepresented.
Yes.
Yes. Yes.
My lord, I
Who are
request,
you? So what is the suit for?
my lord, the suit for partition between the respondent number 1 to 5 decreed. In OS number, my lord, 207 of 2004, my lord.
When
207
is it decreed?
decree dated, my lord, it is in 2018, my lord. I submit date of decree was, my lord.
What happened thereafter? Who
Yes,
are
my
you?
lord.
Who are
I
you?
submit. My lord, the suit in OS number 207 of 2004 came to be decreed on 38/2007, my lord.
2007.
7. That suit is between the respondents number 1 to 5, my lord. The respondents number 1 to 5 prosecuted the proceedings in respect of the suitable properties at item number 1 to 11. In my suit, my number, in OS number, my lord, it is pending in OS number 42 of 2017. I filed, produce annexure D plaint, my lord. Even, my lord, for a moment, my lord, I request.
What is the relationship between you
That's all.
and the plaintiffs?
Kindly peruse the G tree, my lord, produce at page number 28, my lord.
Page number?
28 to 8, my lord. It starts from 27, 28. Yeah, my lord. My lord, this Veerappa and Munemma are the husband. It's in Kannada, my lord. I will read.
With the pagination. You
I'm
said
sorry.
page number?
Annexure C, my lord, 28, 27, 28. Annexure C.
See is some stamp.
Yeah, that is the
Patra.
yes,
something.
that is back page,
Hmm.
my lord. This Veerappa and Muneppa are the husband and wife, my lord. And these both have 3 children, Muneppa, Venkateshappa, and Narayanappa. The present petitioner is the third son, Narayanappa. Sir, Narayanappa's first wife daughter, my lord, Venkatamma is the first wife, and Lakshmama is second wife. This present petitioner is the daughter of Munemma, is the daughter of Venkatamma, that is first wife, my lord. My lord, the proceedings in 2004 proceedings.
You were not impleaded in the suit.
No, my lord. They were filed a suit in 2004 between, my lord.
Remaining all are in they all are impleaded.
Only between my lord, the first branch, that is Sinappa, last, kindly see, my lord, the first son Munemma having 5 children. The last son Sinappa is there, my lord, 5.
So that is in respect of that branch.
No, still, my lord, I have produced the J series.
I'm asking you.
Yes, my lord.
The suit is between the sons of this Munamma and Munappa.
Yes, my lord, exactly
Their
correct.
children have filed as one of the family member has filed a suit.
Yeah, that
for
is the
partition.
daughters of Sinappa, daughters of last son, 5th son, daughter.
2, 3, 4, 5.
That's all. They filed the suit, and the suit came to be decreed in 2007. They filed FDP proceedings before the trial court, my lord. In the meantime, I also filed a suit for partition against all the family members in respect of same properties. So I came to know the FDP proceedings, my lord. I filed an application under 1 Rule 10 before the trial court in FDP 20 of 2012. Kindly page number 22, my lord. So in that petition, my lord, the trial court dismissed the application holding that my father, Narayanappa, yes, Narayanappa separated about 25 years back. And he is having,
That is the finding,
yes,
must be the finding in the suit that is filed.
a suit, we were not parties in this.
Correct. Now
Yes.
you have filed a separate suit.
Yes, my lord, it is
And
pending.
you can seek the stay of the proceedings in that suit.
That questioning the decree of partition, my lord, with that liberty, my lord.
No liberty, if it is, if you're,
No,
if it is permissible, you do it.
No, because the properties are one and the same, my lord. The second submission, my lord, is still the
In that, you can't you seek a stay that because in the respect of the very same properties, no, the final decree proceedings are initiated, it should be stayed.
Yes, correct. What happened, my lord? We have pleaded.
The executing court cannot go into this on your title.
No,
When a
relation,
separate suit is already instituted.
relationship, yes, relationship is not in dispute. Mode of acquisition of property is not in dispute, my lord. Then the property still stands in the name of my grandfather, my lord. Veerappa is also not in dispute. And some of the property stands in the name of my senior uncle, Munappa.
Let's see the finding, page number.
Yes. Impugned order, my lord. It is page number 18.
Please read the reasons.
Yeah. The petitioner's plaintiffs have filed OS number 207 of 2004 against the respondent defendant number 1 and 2 for the relief of partition and separate possession of the partition suit properties. And the said suit was decreed by this court on 38/2007, declaring each plaintiff is entitled 1/6 share in the suit shall properties. And this partition shall be effected by the court of Commissioner Mulbagal as provided under section 54 of CPC. Now this petition is filed by the petitioner to carve out of share which is awarded to them in the said preliminary decree. Accordingly, the said judgment and decree passed by this court has become final and conclusive. On perusal of record, it is apparent that the plaintiff petitioner had filed a suit in OS number 207 of 2004 seeking partition and separate possession of their share in the suit scheduled properties. The said suit was contested by the defendant. This court, on considering the relevant and oral documentary evidence on record, has decreed the suit by allotting legitimate share to the plaintiff petitioners in the said suit properties. In pursuance of preliminary decree passed, the petitioner plaintiffs herein files final decree petition seeking final decree as per the terms of the preliminary decree. The respondent have produced the will mutation registered RTC extract in support of his
There
case.
is nothing wrong with the order. Please come. Agreed with the orders passed in.
No, that document is not at all made available for me, my lord, and we are not available. My sister.
To make it available also, the executing court cannot go beyond the decree. You are not an objector. You want the court to grant you a share where you are not a party to the suit.
No, just I want to bring to the notice of the court, my lord, about the other parallel proceedings is pending in respect of same subject matter.
Even if you bring it to the notice of the executing court also, it can't do anything. You have your remedies elsewhere. That's what court had rightly said. Agreed with the orders passed in IN number 2 under order 1 rule 10 to reduce 151 CPC in FDP number 20 of 2012 dated 25th of November 2019. The implead party is before this court. The respondent's union has filed a suit for partition and the same was decreed. Thereafter, final decree proceedings were initiated. It is a case of the implead party that the property belongs to the joint family and without making him as a party, the defendants have, the respondents herein have filed a suit for partition and according to him, the fraud has been played by the plaintiff in the said suit. In fact, according to him, he has instituted another suit wherein the decree holders are also parties to the said suit and the same is pending consideration for the competent court. As such, is a proper and necessary party to the present final decree proceedings. The executing court had dismissed the application filed with the petitioner herein, holding that in the RTC extracts, it is shown that the property is long back partition among the members of the joint family. And the petitioner has not come to the court with clean hands. And further, the court, further it is observed that a decree, a judgment and decree is passed, and the executing court cannot go beyond the decree, and the executing court cannot decide the rights of the parties of the implead party, or the court cannot decide the legalities or otherwise of the judgment and decree which has attained finality. The court has also observed that the remedy of the petitioner implead party, proposed implead party, is to question the judgment and decree that is passed and accordingly dismiss the petition filed under Order 1 Rule 10. Next paragraph. When counsel appearing for the petitioner submits that when a fraud is played on the court and without even making the parties who are the members of the joint family, when the judgment and decree is obtained, and particularly when the other proceedings are pending, when the other suit is pending in respect to the very same properties, the court ought to have allowed the application as he is a proper and necessary party. He submits that the court had failed to consider the particular facts and circumstances in the case, and if the implead petition is dismissed, the injustice that would be caused to the petitioner. He submits that the petition has to be allowed. Next para. The notices are served in the respondents, no wakalat is filed. Next, having heard the counsel for the petitioner, peruse the material on record. The undisputed facts of the suit that is filed by the respondents is decreed, and a preliminary decree is passed, and that has attained finality. Final decree proceedings were initiated. Now, in the final decree proceedings, the petitioner wants to impede himself on the ground that the property is a joint family property. Whatever is the nature of the property, now the executing court cannot go beyond the decree and decide the rights of the petitioner. As rightly observed by the court, the remedy of the petitioner is not before the executing court, but he is supposed to question the judgment and decree or obtain necessary orders in the suit that is pending before the in the pending suit where he is the plaintiff. As rightly observed by the court, the application, the petitioner is not a proper and necessary party to the final decree proceedings. Hence, this court finds no reasons to interfere.
Liberty may be reserved to take action because, my lord, my suit in respect of all the properties pending. Second submission, my lord, they still.
The court tell you file the suit.
No, because by virtue of the order of, in the writ petition, my lord, the executing court or the lower court.
If the petitioner.
Yes.
If the petitioner. The petitioner is always at liberty to question the judgment and decree, provided it is, if the law of limitation and other, and if law of the limitation permits, and if it is in accordance with law.
Obligement.
How many are there? Call that. Call, or if nobody is there, post it tomorrow. 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 Tomorrow.
Serial number 29, my lord. Name has to be corrected, my lord. It is for respondent 1 to 4. Name is shown as Abhinav. It is Abhinav, ABHI. H is missing, so we did not note.
it is submitted that the name of the council is wrongly printed. Page 3 is directed to print the name of the council as same, take from him.
Please,
This is matter tomorrow.
my lord, tomorrow may I request sometime, my lord. So
This
just
is
get,
matter on 3rd of February.
please.
Interim order there, extended. Completed?
It's only one.
Oh, it has to be deleted. It has to be deleted, I think. That's how it has come part third, that's why it is listed. Because by some mistake it is as a. Where is it listed here? Hmm? No. For admission, why Dharwad matters are listed here? It is, where is it parted? No, where is parted? Oh, thereafter it is, no. No, delete from the caption parted. This is matter before the regular court. Inform them it will be. Yes.
With the permission of the court, serial number 41 minutes. Dismissed.
Dismissed.
For dismissed. Not in fact, the petition has died minutes. I have to bring the LRs on record. That I will do it minutes.
The matters will never be dismissed
Quick.
at the first
Right,
stage. It will come for dismissal and
Grateful
then will be
minutes.
dismissed. Yes.
Madam, serial number 30 ಏನಾಯ್ತು? I could not hear.
ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಮಾಡ್ರೆ ಇರ್ತದೆ ಏನ್ ನಂಬರ್ ಇದು 27,535
ಓಕೆ ಡೇಟ್ ಆಯ್ತಾ? ಆಯ್ತು ಆಯ್ತು ಓಕೆ.
ಧಾರವಾಡ ಬೆಂಚ್.
Proceedings on ಮಾಡ. Audio, video, video
ವಿಡಿಯೋ ಆನ್ ಮಾಡಿ.
video on ಮಾಡಿದಾಗ ಇಲ್ವಲ್ಲ. ಇದಾರಾ?
ಇಲ್ಲ.
CH ಶೆಟ್ಟರ್. ಅವ್ರದ್ದೇನಾ ಅದು? Release from part.
21 months.
25.
ಈ ಮಂತ್ ಸರ್ 21.
ಹಲೋ
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಅಲ್ಲ?
ಸರ್ ಶೆಟ್ಟರ್ ಸರ್ ಧಾರವಾಡ ಅಲ್ಲ?
ಹಾ ಮೇಡಮ್.
That even matter is released from parted and it is to be posted before the roster bench, ma'am.
ಎಸ್ ಮ್ಯಾಮ್.
That order has been already passed.
ಎಸ್ ಮ್ಯಾಮ್.
It is released from parted and the matter
Yes.
is to be posted before the roster bench.
ಆಲ್ ರೈಟ್ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
Okay.
ಥ್ಯಾಂಕ್ ಯು.
This one.